नमस्कार दोस्तों, प्रॉपर्टी एक्सपर्ट की इस नई वीडियो में आप सबका स्वागत है। प्रॉपर्टी से रिलेटेड किसी भी प्रॉब्लम का सलूशन पाने के लिए प्रॉपर्टी एक्सपर्ट्स के वीडियोस को जरूर फॉलो करें ताकि आप किसी भी तरह के स्कैम में ना फंसे। Hi everyone, I'm an advocate Uda Kapoor, working as a legal SSA at NRI Legal Services. Registration of an immovable property is both a statutory and a prudent practice that is eminent for transfer of property in India. The burden for registration of an immovable property lies on the buyer. Therefore, today I will apprise you with the steps involved in the registration of an immovable property purchased by a non-resident Indian, that is an NRI. Before we look into the steps involved in the registration of a property, it is important for us to focus on first, what is the criteria of a non-resident Indian? Second, an acquisition of an immovable property by an NRI. Third, the essence of registration. Fourth, what are the consequences for non-registration of an immovable property? Fifth, what is the registration fees involved? And sixth, what is the time limit for registration? Who is a non-distant Indian, in layman language, an Indian citizen residing outside India? For business employment or for any other purpose for indefinite period of time is regarded as non-Indian. However, the statutory status of a non-resident Indian is certain under FEMA Act and the Income Tax Act. As for the FEMA Act, an individual's residential status is certain on the basis of that individual's intention to stay in India, wherein under the Income Tax Act, an individual's residential status is determined on the number of days that individual stays in India. In a recent amendment, the number of days under the Income Tax Act has been reduced from 182 days to 120 days. Therefore, if you are residing outside India and you are not covered under any of the two concepts being explained to you, will automatically be deemed as a non-resident Indian. Now we will discuss about acquisition of an immovable property by a non-resident Indian. It is a common misconception that being an Indian citizen, a non-resident Indian is permitted to buy any sort of immovable property. However, according to the Reserve Bank of India's Master Circular on acquisition and transfer of immovable property by NRI PIO or foreign national, an NRI is strictly restricted from buying any agricultural land, farmland or plantation land. However, this does not mean that an NRI who has an existing ownership or in a near future may be given an ownership based on succession to such properties will be restricted on null and wind. Furthermore, an NRI does not require any sort of special permission or permission from Reserve Bank of India to purchase any number of residential or commercial properties in India. Now we will discuss about essence or registration. Registration process and other intro cases. There are two are governed under Registration Act. To understand the registration process better, it is important for us to understand the constitutional intent behind it. The epic score in the matter, Suras Industries Private Limited versus State of Haryana and others duly observed that the Registration Act came into being in order to provide orderliness, discipline and public notice for all the transactions relating to immovable properties and further preventing any sort of forgery. Furthermore, once a document has been registered, it becomes a public document. As it is available readily in the public domain, such a public document acts as a caveat towards the general public in regards to any legal rights that are arising out of or affecting an immovable property. It would further prevent any sort of misrepresentation or fostering of documents. Now the question remains, are all documents required to be compulsorily registered? The answer to this is no. The documents which are covered under Section 17 are compulsorily required to be registered. Therefore, it is to be taken into account all the documents that relate with transfer and sale of an immovable property and are more than a constitutional amount of ₹100 and are not testamentary instruments are required to be compulsorily registered. This would include documents such as sale date. Now, there are certain documents that do not require compulsory registration and are covered under Section 18. Such documents include wills power, returning, and even agreement to sale. Now we will discuss about what are the consequences of non-registration. As discussed earlier, there are certain documents which are compulsorily required to be registered, and opting out of the same would incur a particular individual legal injury by first of all invalidating the legitimacy of any transaction that has consequent sale or transfer of a property. Second, invalidating the evidential value of this particular transaction in the eyes of the court. And lastly, it would pave path for misrepresentation and fraudulent activity. Now we will discuss about the stamp duty. A buyer is bound to pay a certain amount in the form of tax levied by the state government to generate revenues. This is usually a small percentage of the saleable value of the property that amounts to, in most states, 1% of the value of the property. Now we will discuss about time limit for registration. The time limit for registration of any compulsory required document under the Act is within 4 months from the date of execution of such a document. If it happens to be so that you are not able to register this particular document in the stipulated time period, you are still given the time to register this particular document in succeeding 4 months. Now, if you are not able to register the document in the succeeding 4 months too, yet you are given an opportunity to register this particular document by maxing a confirmation deed along with a stamp duty paid on the current market value. This document would further be taken to adjudication before the collector and then would be registered by the joint sub-register. Therefore, it is recommended that rather than taking this expired document, which is already past 8 months from the date of execution, you shall prepare a fresh document. Now we will be discussing about what are the steps that are involved in the registration of an immovable property that has already been purchased by a non-distant Indian. All documents in regards to sale and transfer of immovable property are to be presented before the sub-registrar's office, in whose sub-district the subject property is located. It is to be noted that it is the discretion of the officer at this sub-district's office to be present in any residence of an individual who decides to register the document with regards to an immovable property. Furthermore, such documents require proper representation before the sub-register. Therefore, the buyer, the seller, and the legal representatives have to be physically present before the sub-registrar's office. In case a legal representative or an assignee, a proper power attorney has to be produced before the sub-register. Now, in case where the vendor dies, signing a particular document which is pending registration, the document can still be registered provided the legal errors have been implemented by the purchaser in the following manner. First, you can move an application in the Honorable Court for a probate or an order that tends to complete the legal heirs to represent the demised vendor before the sub-register. Secondly, you can prepare a deed of fact that entails all the facts in regard to the dismissed vendor. This deed has to be duly signed by the purchaser and the legal aids, and once it has been done so, this registered sub-registrar's office would deem this as to be a proper document for registration. Now the authorized signatories have to present a proof of identity which includes PAN card, Aadhaar card or any such document that has been authenticated by the government as a proof of identity. In addition to these documents, original documents that have consequent this transfer of the immovable property such as CLD and a proof of stamp duty and other prerequisite documents are to be presented before the sub-register for a successful registration of the immovable property. Hence, given a discussion, it can be concluded that the registration of all the documents related to immovable property is compulsory in nature, and further the steps involved in the registration requires a good understanding of legal intricacies. Therefore, I would advise that a proper legal assistance shall be taken for registration of an immovable property. दोस्तों, उम्मीद है ये इन्फॉर्मेशन आपके लिए हेल्पफुल साबित होगी। आज इतना ही। अगर आपको ये वीडियो पसंद आए, then share it with your friends. Do watch all our videos and educate yourself regarding property. Be with us and thank you.